Sometimes we forget about it. We're more concentrated to analysis, but I think it would be misleading for us only to analyze. I suggest only to make a synthesis. So, let us to see what is the place of the International Criminal Court in the context of other international criminal tribunals. I will read several tribunals here. It's not all of them, but let us see their practice and how this practice coordinates with practice of International Criminal Court. I will look at the practice of International Criminal Court for Rwanda, International Criminal Tribunal for the former Yugoslavia, Special Court for Sierra Leone, Special Court for Lebanon, and of course ICC itself. First of all, let me raise a question about legal way of the creation of international criminal courts. Let's start from the Yugoslavia and Rwanda tribunals. All of them were created by the decision of the Security Council. But again, if we look into the United Nations Charter, we will find very interesting thing. There is no articles that could be a legal justification for the Security Council to create these tribunals. Of course, in the resolutions of the Security Council there is a reference to the Chapter 7, but this reference in no means justifies the creation of this tribunal itself. This reference explains only one thing, that the Security Council would like that this resolution be treated as legally binding to all states. There is also a very interesting thing. If we look into the travaux préparatoires, stenographic notes of these meetings of the Security Council when these resolutions were adopted, we will find very interesting speeches of the representatives of states who said, for example, the representative of China said indirectly, yes, we understand, we just adopted decision without legal justification, but politically, because of political reasons, we voted in favor. So, even the members of the Security Council understood that the creation of these tribunals was illegal. The same could be said in a certain extent to another tribunals. For example, the Special Tribunal for Sierra Leone. The Constitution of Sierra Leone does not provide for any other courts, including this special one. If you look at the legal way of the creation of International Criminal Court for Lebanon, it is again very, very interesting example of the violation of international law. Here it is the citation from the speech of the Russian representative in the Security Council after the adoption of the resolution creating this tribunal. You could see what the Russian representative said. He said the arrangements chosen by the sponsors is dubious from the point of view of international law. The treaty between the two entities, Lebanon and the United Nations, by definition cannot enter into force on the basis of a decision of only one party. To make it clear what happened, this tribunal was created by the treaty signed between Lebanon and the United Nations. But Lebanon refused to ratify this treaty. Okay, said Security Council, we're entering into force this treaty by our resolution. Again, we see very, very dangerous precedent of violation of the very essential basic norms of international law. That international law is constructing and building by the voluntary participation of the states. So, analyzing the very first question of legal creation of these tribunals, we see that all of them were created well, I'm not diplomat as this Russian representative in Security Council who said it's dubious from the point of view of international law. Let me say it quite straight. They were created illegally. Let us to see the what was the legal activity of this International Criminal Courts and Tribunals. I think the example of Special Court of Sierra Leone is quite interesting one. You see that the main trial of this court is Charles Taylor trial. Sometimes it's very interesting to see who are the judges. Here are the three main judges, but they were not the only one who constitutes the bench. There is also a very interesting judge, Mr. Mezyaev from Senegal. And let me present you two pictures about the bench before the pronunciation of judgment and after it. So it clearly shows that something happened with the judge. And this judge is not fallen sick or refused to attend the hearings. The judge was removed by his fellow judges. Why? I still could not excuse myself from a crime I committed myself. It was a crime when I sit in front of a computer when this judgment was pronounced in live, and I did not press the button to record it. Because after I could not find it in internet. You couldn't find anything in YouTube. Anything. Any wishes. But this, what happened on this pronunciation of judgment, you could not find anywhere. What happened? After the three judges said, Mr. Taylor, you are guilty. They stand up and trying to leave the courtroom. But in this moment, it was clear that somebody started to talk. My first impression was that it was Mr. Charles Taylor who is talking, probably expressing his viewpoint of these judges. But later on, we all realized that the fourth judge is still sitting and that's he who is talking. He is trying to say something, but suddenly the microphone was cut and the blind started to put on the glass that prevents the public to see what's going on in the courtroom. So that's how the court officials treat the fourth judge. But after that what happened, the judge was removed, but later on he was able to express his position on what happened in the trial. Mezyaev said, international justice cannot be based on rumors. They are mass crimes. We must have the highest standard of proof. But this highest standard of proof never been provided in this trial. Let me add you from my own practice of participation in international criminal tribunals. There is a very big contradiction between our expectation from international criminal tribunals and reality. I never seen the lowest standard of proof in my life what I see in international tribunals. There are some other expressions of Mr. Mezyaev, you could see it on the screen, but the main idea of what Mr. So tried to say, that this judgment that three judges read out in the court were never discussed between them. Where this judgment came from, I don't know, said Mr. Mezyaev. But this judgment was not discussed between us. Special Court for Lebanon. It is another interesting example how international courts are destroying international law. And I think I am coming, even the moderator is showing me that I have only a few minutes. I think I need to announce finally that my idea is we are coming to the idea that international courts are destroying international law. Example of this special court for Lebanon. Just one example, trial in absentia. International law says that CCPI is Covenant for Civil Political Rights, that the determination of any criminal charge against him, everyone shall be entitled to the four minimum guarantees to be tried in his presence. Special Court for Lebanon said special tribunal shall conduct trial proceedings in the absence of the accused. ICC, the case prosecutor versus Mr. Chewy. I hope that you enjoy this. This is quite a gem in my presentation because it's completely new idea. The judge acquitting Mr. Chewy said the following: accused, the fact that we are acquitting you does not mean that you are innocent. I think that it should be known for us, lawyers. We should take this idea because International Criminal Court said that it's produced the highest level of justice. It was also a very interesting case when the same judge convicted Mr. Kazan several days ago, and I really was very much awaited the pronunciation of the judgment. This day I pressed the button record, but unfortunately nothing happened because I expected the judge said, accused, we are convicting you, but this does not mean that you are guilty. But unfortunately it does not happen. We still have only this expression. The same judge. So, I understand that my time is, yes, almost finished. And let me just bring my final conclusion. What is this ICC is about? We clearly see that all these courts, and ICC among them, are very sharply, very consistently violating international law. There are two main directions in this violation. First, the court is breaking already existed norms of international law. And second group of violations, it's a producing law itself without any justification for that. Of course, you understand that the court could not produce law. Court is only applied law, but not international criminal courts. The international criminal courts are clearly starting to produce. And this brings me to idea about the definition of this activity of international criminal tribunals. And I put it in the context of the history of international law. We all know that before 1945, the international law was very different. This international law treated war as a legal instrument for states. It accepts colonialism as a legal tool. It accepts the division between civilized and other states and so on and so forth. And only after the creation of the United Nations Organization and United Nations Charter, international law became different. This law started to make by all members of the international community and the interest of all members of the international international community. That's why we start to call this modern international law as progressive international law. This word progressive really reflects the essence of this new law. But whether after 1990s the international law retained its main features, in my opinion, it is very clearly, we can very clearly see that it is not. The international law became deformed, and this deformation would be called regressive and even repressive. In this slide, I enumerated the main features of the regressive international law. To conclude, if we listen about the activity of International Criminal Court and tribunals, and ICC especially, from mass media, we could not understand the reality of this institution. But if we put this court in the context of the modern development in international law and international relations, we start to understand that these court and tribunals were created with that purpose of the destruction of international law. So this destruction of international law is not collateral damage when these courts are trying to achieve the officially proclaimed goals. No. The real idea, the real goal of these courts was to create new repressive international law. After we understand this, all these strange events in the practice of international criminal tribunals becomes clear. Trying to obey the procedure, I conclude my presentation, and I thank you very much for your attention.